SJC-10787, Guardianship of Erma.
May it please the Court, Attorney Alice Whitehill-Weisberg. I represent RM in this matter. We're here specifically to address two issues, I believe, of constitutional proportions. And those issues are specifically what notice is due a person who is, where there's a request for them to be subject to an order to involuntarily administer antipsychotic medication, up to and through and including forcibly injecting the individual with antipsychotic medication. What notice? The notice takes, that question has two parts. One is time. How much advance notice does a person need of the proceedings in order to be able to mount a meaningful defense as required by due process? The second part of it would be the substance. What information has to be provided to that individual as far as in advance as this court deems proper in order to, again, allow them to mount a meaningful defense?
Should we deem the latter argument waived because there was no request for a continuance here?
I don't believe so. Now, I was not trial counsel. My understanding of how it happened was that the parties were very close to an agreement on a treatment plan, that at the very last minute, that agreement fell apart, and it wasn't until my clients got into the courthouse that they, in fact, received this signed affidavit, medical certificate, and treatment plan. I think in my understanding also of that particular court is it's incredibly busy, and there's often it's very difficult to even get a word in, especially to change gears when things have started rolling. I think that he stated his objections, whether or not trial counsel should have asked, as I'd like to think I'd have the presence of mind to do, but may not, for an actual formal continuance in order to be able to prepare. That would have been better practice, but given the circumstances of that day, but even if that argument were waived, certainly this court has the right, and I would say almost the duty in this case, to address this issue given the fundamental rights involved. As one or several of the amici have pointed out, the number of these cases is just rising and rising and rising, and they're becoming a very significant part of the probate court's docket. And the statute, both the statute in effect at the time of the hearing and the UPC, leaves some very important unanswered questions that I believe need to be addressed directly by this court that arose in the context of this hearing and in many others, but we're before you today. So I don't believe that he waived it. I believe he made an attempt certainly to state his objections to the procedure in the hearing, to the fact of the hearing becoming sort of that it needed to be a contested hearing where it was set up and treated as an uncontested hearing. That's how it was marked originally because they did think they had an agreement.
So, I'm sorry. It's on the it's waiver with a twist a little bit. I hear what you say. Do you think that this goes to notice? Although he didn't, Mr. LaFrance, do I have the name right?
DeFleece.
DeFleece, sorry. Mr. DeFleece didn't get the affidavit. I understand that. But reading a little bit of what he said, he knew that the issue was prolixin, and he knew that the issue was injecting medication, right?
Those were one of the issues. The agreement, as I understand it.
About triathlon.
The Trilofan.
Trilofan,
She
I'm sorry.
agreed to, yeah, they're hard. The Trilofan, she had been agreeing to take, and that was
Yes.
part of the agreement. And then she agreed to one backup agent, Abilify.
Right.
So that if the Trilofan stops working. However, the treatment plan, and she'd been very clear about her objection to Prolixin and to any injectable.
Right.
But there were a myriad of other medications on that treatment plan as well that were not part of a previous treatment plan that had been allowed by the probate court. And in fact, the previous treatment plan in 2006 that had been allowed by the probate court was both very limited and also put very strict restrictions on when an injectable medication could be used, and in fact only allowed its use after 24 hours of refusal of her taking oral medication. So there was a bit of a hammer there, but it was set out in that.
And I think what you're saying is that although he may have known conceptually what Department of Mental Health was looking for, he did not know these details at all.
Absolutely. I mean, it's not just the medications. Or first, their position is all we had to do is let you know that we're filing a Rogers, essentially, that we're going to be treating with antipsychotic medication. I think that clearly is not enough.
Yeah, I was sort of getting under that because he obviously knew more than that.
He knew some more of that, but there was this back and forth going on, and until you have the actual treatment plan, because the dosages are also important. Is there going to be certain caveats? Now, they say, DMH argues in its brief that, in fact, the injectable medication would only be used as a medication of last resort. That is not how the treatment plan or order, as we see from the 2006 order, you can limit it in that way. But it's not. And someone on the outside who doesn't have benefit of someone saying, wait, but what we meant is, would not know that. So I think we actually have agreement between the parties at this point that at a minimum, the notice that is required is a 7-day notice of not only the petition for the authority to treat with antipsychotic medication and determine incompetence or determination of competency, but also that with that petition has to be filed and served.
You say there's an agreement of the parties on these?
The DMH has changed its position.
Not in the brief.
They submitted a supplemental brief as of, I got it yesterday, which on the record I will, I oppose because I got it yesterday. And, but I think they would waive their argument of that in their brief. But they did switch their position. I think we are all in agreement. Obviously, he can address that if I'm misstating it, that what is required, what we would request the court say is that what is required is that the affidavit, the medical certificate, and the treatment plan all be filed with the petition for determination of competence as well as authority to treat with antipsychotic medication. So that at least 7 days ahead of time, the purported incapacitated person has the opportunity, has 7 days opportunity to really do an analysis, to hire an expert if necessary, to talk to the people.
So what is in dispute, if that's true, and I understand Mr. Porter may say it's not, but assuming for the minute it is, what is in dispute then at this point?
As far as the notice provisions, I don't believe that there are key issues in dispute between the parties at this point.
Before you get to what I think you're going to say, is there a practice out there as to an order, a previous order that is about to expire or that has expired? Is there a practice as to how these cases are handled? Is a new petition filed generally within the period of time of the initial order or of the previous order? And is 7 days' notice given for that kind of a petition, or something less than that acknowledged for a petition that's filed within, a renewal petition that is filed within the original order?
Yes, if the treatment plan in effect at the time had not expired, then they would have a motion, file a motion to extend the treatment plan.
Just done by motion?
Done by motion. If there's no disagreement, then in fact they can go in on affidavit, and the witnesses are not required. If there's agreement, but if there's disagreement, we mark it up for a contested hearing, an evidentiary hearing, in which we would call our respective doctors, whatever other witnesses we'd want to call, and have a contested hearing as to the treatment plan.
Yeah. Now, if there is during the period of an order, for which an order was allowed, if the department proposes to change the treatment plan, what is the practice? Is it that you have to give 7 days notice, perhaps by motion, and that you have to say in the motion what meds you're proposing to add, that the department is proposing to add?
Yes, there would be a motion to amend the treatment plan, and that would be filed and served on the other parties. I believe that would be 7 days ahead of time, and it would list the proposed amendments. Now, those hearings, when the treatment plan, if it's on review and they want to alter the treatment plan, that is generally not done administratively. You have to have a hearing. But if they want to, in the course, the middle, say, not up for review, they find they need another medication. Or, for example, I could also go in representing the individual saying, they're having adverse effects to this particular medication. I'd like that stricken from this treatment plan. That would be marked for a hearing.
Now, is there a practice or a common understanding, to your knowledge, with respect to what happens after an order has expired? Or is there no practice?
No, if an order is expired, the order's expired.
So do you have to start all over
You have to
again?
start all over again.
You start all over. Now, the guardianship itself is still in place, the underlying guardianship. But our position certainly is that if there is no treatment plan, and part of our issue is with how these motions were framed. They were framed as to renew, and as if there was something existing when in fact there was not. That treatment plan had expired. The last probate court treatment plan had expired
I don't mean
in
to interrupt you,
2007.
but you've only got 3 minutes left.
Oh,
you
I'm
may
sorry.
want to get to something
Well,
else.
the other issue that is of grave concern to us is what evidence is required, what type of hearing is required, and what evidence is required. And unfortunately, this issue remains with the new UPC as to when may the court rely exclusively on affidavit or other documentary evidence, taking in no testimony at all.
Well, on that point, if I understand the agreement, assuming it is an agreement, that you would get 7 days' notice and you would get the affidavit, could you, as a procedural matter, look at this and say, no, this isn't going to work. I want this to be a contested hearing, and I'm going to bring witnesses. In other words, does getting the notice take care of the problem of can you do this on affidavit, because you would have the right to call witnesses?
I think that I'm not sure it takes care of the problem fully, but it certainly addresses the problem in that there's enough notice to know, no, I have to bring another doctor in. I need to subpoena the DMH witness so that they're there for testimony. But there's still the question of, can the court
Just say, I won't hear it?
Essentially say, I won't hear it, or not require that person to testify. In this case, the court took no testimony. My client was allowed to speak. It took 28 lines of testimony.
But as you said, you got it on that, not you, but she got it through her counsel on that day, and and nobody asked for a continuance, so, and Nurse Patch wasn't there. So, I mean, it's not clear that he wouldn't have heard it had she been there, right?
It's not clear that
Judge Caton wouldn't have heard testimony had somebody been there. I mean, these facts didn't allow for it, but it's not clear to me that it would have gone on affidavits if somebody had said, I want a witness here, and here she or he is.
Well, I think with having Ms. McClellan there, had it been treated as an evidentiary hearing, it was clear the court didn't treat it that way. It was clear she wanted to speak. She kept interrupting.
Yes.
And she's an exceedingly bright woman. And you know, as garbled as it may be, she makes some really key points.
Could the Guardian properly have filed a motion to extend the Rogers? Wasn't that what happened here? The Guardian himself did this.
Well, the Department of Mental Health moved to intervene.
Yeah.
The Guardian was the initial petitioner for the guardianship and for the authority. But DMH intervened and filed the new set of motions, which the court allowed, where to be the petitioner just for that purpose, for that hearing.
So it's your position as a matter of due process that it would be improper for the judge to decide a contested issue on affidavits. Is that?
Yes.
That isn't by statute or by the UPC, which is a statute, but by as a constitutional matter.
I believe it's all three. I believe the statute requires it, and I can rely on my brief in that if you like. I believe that due process requires it as well, and both the new and old statute, I believe, required it.
How does the court know whether or not to put a case on for a particular day, whether it's going to be uncontested or contested?
I believe that the person who's filing the motion asks to have it marked up a certain way, tells the court whether they want to contest it or uncontested, or in some cases, if that doesn't happen, I think the court just makes its own determination.
And was that DMH that
yes.
asked that it be set for this particular day?
Yes, DMH did the scheduling of the motion, as far as I know. They were the proponent of the petition to treat and the motion to intervene. So I believe they marked it up. Again, since I wasn't trial counsel, I don't know the exact particulars.
How would trial counsel know whether that was on for a contested or an uncontested hearing?
The notice says so, doesn't it?
Yeah, I think with the notice that's sent out, and again, I think that initially the parties anticipated that it was going to be uncontested, that they had an agreement. And that it wasn't until they got the treatment plan, or I think the day before when there was a conversation about whether Prolixin would be on it or not, which was the last stumbling block, and it was like, look, my client says no to Prolixin, you're saying you insisted it being in there, bam, we have a contested hearing. But they were scheduled for the next day, and I think part of the issue was that, and I'm not 100% sure, but my client was scheduled to go into surgery, well, to have some evaluation later that day, and then also have a surgery several days later. And so I think they felt some urgency to at least get before the court. But I'm not sure, as not being trial counsel, I apologize.
All right, thank you, counsel.
Thank you very much.
Good morning, and may it please the court. William Porter, Assistant Attorney General, here on behalf of the Department of Mental Health. I think the best place for me to start is to identify where we stand on the notice issue. In the original briefing, there was a solution to that issue, I'll confess, and it was in plain sight and we missed it. But we now agree that 7 days' notice is required when a motion to review or renew authorization for antipsychotic medication is filed. And the reason for that is it's simply Massachusetts Rules of Civil Procedure 6C, which requires, as the court knows, that a motion and any supporting affidavit be filed not less than 7 days in advance of the hearing.
So you don't look to Section 6 or 7 of the old statute or the UPC? It's as a rule of civil procedure?
That was where some of the confusion was in our original brief. This is not an original guardianship petition, either a petition for a permanent guardianship or temporary. The former statute, Chapter 201, Section 7, and the Uniform Probate Code both address the notice requirement there, which also happens to be 7 days. So we disagreed on that point simply because this isn't a new guardianship petition. So consequently, in our original brief, we did address the question of due process on the facts essentially as stated by the appellant. But I would urge the Court now that there are at least 2 reasons not to reach the due process question as it relates to notice. The first reason is that the notice issue was not waived or was not raised in the trial court, and we believe clearly was waived. It's nowhere in the transcript. And trial counsel also filed a motion for reconsideration several weeks after the decision came out. He didn't raise lack of notice there. And I think the reason is easy to discern from the transcript, because it appears from the transcript that trial counsel was very familiar in detail with the proposed treatment plan. He had identified 2 medications that were acceptable, one in particular, Prolixin, that his client objected to strongly. So,
but he plainly didn't have the nurse's affidavit providing all of the background, because that wasn't even signed.
If I can clarify that as well. Certainly on the state of the record, that's what the record would say. I will concede that the certificate of service in this case does not show advance service of the affidavit. If the matter had, the motions were indicated as having been served over 2 weeks ahead of the hearing in a certificate of service, but not the affidavit and the medical certificate.
The affidavit itself is dated February 11th.
Let me clarify that as well. If the issue had been raised, if notice had been complained about at the hearing, department counsel would have represented that she also served the underlying affidavit and medical certificate on January 26th.
Unsigned?
Unsigned. It would have had to have been unsigned.
The examination didn't even take place till February 2nd. How is that possible? The
I think what
affidavit
she was-
concerns an examination occurring on February 2nd.
I think what she was seeking to do, RM was scheduled to be discharged from the hospital on February 2nd. The department knew that it wanted to get a treatment plan in place if the court was going to authorize it as soon as possible because of this woman's long history of refusing medication and hospitalizations, 30 hospitalizations over the course of her
32 by
life.
the time of this case, I think.
And so I think there was just a timing issue. As far as I understand, counsel wanted to get the wards counsel, DMH counsel wanted to get the wards counsel as much as she could.
But in any event, you agree now that there has to be formal 6-7 days notice under the rules of civil procedure regardless of anything else?
Yes.
And
Yes.
that
And
notice-
we did submit on Tuesday, regrettably somewhat late, a supplemental brief that articulates that in writing and formally withdraws the arguments we made on due process, again, because we would strongly urge the court not to reach due process.
And that notice includes certain documents that must be made part of that?
Yes. The motion for review or continuation of the authority to administer antipsychotic medication, the clinician's affidavit, the treatment plan, which is typically attached to the affidavit, and then another document that is somewhat overlapping with these, which is also specifically referred to now in the Uniform Probate Code, the medical certificate. It's a form, and it's a document used in guardianships and Rogers hearings to set out essentially an overview of the individual's medical and psychiatric condition.
If I can
Mr.
turn
Porter, what's your position if an order lapses? Do you have to file a new petition, or can you do it by motion?
It's my understanding that it can be done by motion, because in these cases, there will be an underlying guardianship proceeding that will be ongoing. So if there's a guardian appointed and who remains appointed, they will, that will be kind of the ongoing case. That's the vehicle within which these motions are filed.
But guardians appointed, and so, and let's say there is no Rogers order in place at all. There is a proceeding, and it's an evidentiary proceeding, correct?
Yes.
Well, I suppose if people agreed, maybe it wouldn't be, but it's evidentiary, people testify, right? Would you say, I think this is what, well, I'm going to ask you this, I think it may be the same question Justice Spino is asking. If that's happened, and then that lapses, and so now it's a year or something later, do you, even though you now have a guardian, but do you treat it as though you're just ab initio as far as a Rogers order goes?
Not exactly. When the Rogers order expires, it is expired. So the guardian cannot continue to act under it. But I don't believe you start ab initio. The cases describe the later Rogers hearings as looking for whether there's been a substantial change in the condition of
If
the
you've had
individual.
2 years of nothing, I mean, I can't remember now how long this
Well,
period is.
it actually wasn't, Your Honor. Just to clarify, there was a long interval of hospitalization during those 2 years. And so the RM in this case was actually under treatment orders under a different regime, which is Chapter 123, Section 8,
yes.
which is the regime that's followed when there's an involuntary commitment. So there really wasn't this long interval. There were the probate court orders that ended in 2006. That's when RM had the automobile accident, spent many weeks in Beth Israel recovering, both the medical unit, the psychiatric unit, then was transferred to another hospital. During that time, she was under the Chapter 123, Section 8 commitment orders, which include treatment plans.
But that's all relevant evidence, but procedurally, why wouldn't it be the same as if you didn't have a Rogers order, procedurally?
I'm afraid I don't understand the question.
Well,
It's
in other
expired. It's expired.
Yes.
Words, so
You have to
I
have a
thought you were saying
substituted
if
judgment
yeah.
hearing
Yes.
all over again.
Yes, exactly. And I think that was the intent of this hearing.
You do have to have a substituted judgment hearing.
Yes,
all over.
absolutely. Oh, absolutely. I'm sorry, I missed the import of that.
And with regard to,
sorry. This hearing required both the essential determinations, a determination of the RM's incompetence or inability to make her medical treatment decisions, and a determination of substituted judgment that if competent, she would choose to accept the treatment in the treatment plan.
now, I know that under the previous statute, at least you say it permits affidavits to be submitted even in a contested hearing.
Yes.
Under the new UPC, is that still permitted?
The new UPC has a slight, well, I shouldn't characterize it. It's different. The language that the appellant relies on is reproduced in the new UPC. It's the former Chapter 201, Section 6E. And our argument is that that section, both in Chapter 201 and now in the UPC, which became effective July 2009, that section specifically and only addresses the situation where the allegedly incapacitated person does not appear. And it sets out specific requirements for that. It allows the hearing to go forward if there are extraordinary circumstances and if counsel for that person is present. And then as the statute reads, provided, and then it lays out 2 conditions, that there aren't disputed issues of fact and that the judge makes findings as to why there's no need for oral testimony.
But where there is a contest, is it your view that you can offer an affidavit of a clinical specialist?
I think it depends on the nature of the contest, and I think that
If
as
there's
we've
a
argued,
contest as to the nature of that person's testimony, or as to the opinion of that person, or as to what that person is proposing.
well, certainly any time the allegedly incapacitated person seeks to procure testimony, it should be provided. Our main point in this case on the question of testimony is that it was never asked for. First of all, we say it was not required by statute, but secondly, counsel for the ward, although he made a passing objection to the receipt of her affidavit, He never asked that she come and testify. He didn't ask.
So your position is that due process is satisfied as long as they have the opportunity to cross-examine by calling them,
Absolutely.
but that you're permitted to proceed by affidavit in the absence of that kind of request?
Absolutely. If there is an opportunity, and there clearly is in these cases, witnesses can be subpoenaed. The department's policy and practice is if they receive a request to produce their clinician, they will bring the clinician to the hearing.
Can I just ask a clarifying question regarding how you've constructed what this process is about? The way you seem to describe it is it falls under the general umbrella of a guardianship. And so within the structure of a guardian is appointed, you may act by motion. Is that correctly stated?
That's my understanding, Your Honor.
And therefore, if that's true, then nothing there's no res judicata question here. Its motions tend to, are by nature, in the context of an ongoing action, temporary. You may proceed next week to file another motion. The guardian here, on behalf of RM, can go into court on a motion and say, you know what, I want that hearing. We don't really like what's happening, and in fact, it's not really good for her. She's today again said something's not going right with this medication, so we're going to have a hearing. That's one construct. I thought, perhaps things have changed, that there was one petition with respect to the guardianship, and then there's a separate proceeding, also by petition, called a Rogers proceeding.
Yes.
It's not by motion, it's by petition. And so you have to start over by petition, and that's an action, and there's a conclusion, there's an adjudication, has a beginning, middle, and an end. But that's not how you describe it.
Well, Your Honor, I may not be appreciating the semantic distinctions between
It's not
petition and motion, but I think there's a conceptual agreement, which is that the in connection with the guardianship, authority to treat with antipsychotic medication needs to be separately obtained by a proceeding, a petition, and there are two elements to that: proof of incompetence and then the substituted judgment determination. Those orders are time limited. They can't extend beyond 1 year. They need periodically to be reviewed. And when they're reviewed, the determination is, as I understand it, largely wide open, except the cases do say that what the court looks for on the review is whether there's a substantial change in the condition of the incapacitated person.
But, and you're saying in this case, given the lapse,
Yes.
that you're back to use Justice Duffley's language, you need a Rogers petition.
Well,
I mean, if you accept
If-
that it's something different than just a review.
I would hope that it wouldn't we wouldn't be tripped up here because
But I think in
DMH called it a
substance you're
motion.
saying, yeah, but you're saying substance is the same thing. You have to prove incompetence, and you have to prove the substituted judgment all over.
That's correct. But also, I believe in successive petitions, it is a lesser burden, because it's a question of there is such it's guardianship of Whedon is one of the cases that says that. There's such a long history here that starting over as if there were no history every year, I think it's acknowledged that isn't entirely the standard. But
Is that the same whether you file a request to renew before the end of the 1 year or even after a lapse?
I believe it is, Your Honor, but I'm not 100%, and if I'm wrong, I will correct myself. So in any event, I'm hopeful that we've clarified where we stand on notice. It's very important there, though, I think, that the issue wasn't raised in the trial court. Had it been raised, and it's understandable that it wasn't, because it looks like counsel knew what he was dealing with, but had it been raised, the parties could have sorted it out. We could have figured out what was going on. And the question, again, of oral testimony is really bound up in that, because the appellant would argue, I think incorrectly, under the former Section 6E, 2016E, that oral testimony is required in every single case, and our position is that that's not required on the face of that statute. That section only relates to circumstances where the ward isn't there. But also, it should only be taken if one of the parties asks for it. The allegedly incapacitated person might not want the testimony of the clinician. Their case might get worse if the clinician appears and testifies.
Is she currently under this treatment plan?
No. And this is the other thing we mentioned in our Tuesday submission, is the case is moot. This order expired a year after it was entered. In the intervening time, RM was involuntarily committed to a psychiatric facility under Chapter 123, Section 8. In connection with that, there have been treatment orders entered under 123, Section 8B. Those are the currently governing treatment orders. She is currently in a psychiatric facility as an inpatient. So
this may reoccur when if she's about to be released, we'll go through this Rogers process again.
Some of these issues could reoccur, certainly, and that has been the court's position in these cases when they've come up. But we would encourage the court not to reach issues, even if you find issues that are important that will recur, not to reach issues you don't have to reach. It would be our position that none of the constitutional issues
You would say we don't, I mean, in that theory, we don't have to reach any because it's moot.
Well, I think you could legitimately decide that. Once we've clarified the notice issue.
But if it were to recur, it would recur under the new UPC, not under the previous statute for which this proceeding was adjudicated.
The question of whether oral testimony is required. That same language is reproduced, and we've cited to it.
There's no
in
difference,
the
statutory
UPC.
difference.
There is a statutory difference. Under the former Chapter 201, it said explicitly in, I believe, subsection 6C, that the court may consider the petition or motion on affidavits or testimony. That phrase doesn't appear in the UPC. But the same language does appear to guide what happens when the incapacitated person cannot attend the hearing. And that's where the two conditions are set out, where the court needs to make findings. But I will emphasize that the UPC very much contemplates receipt of documentary evidence. It has a whole procedure for receipt of these medical certificates. And in the last section, I believe it's subsection F of the, I don't have the site immediately in front of me, it refers to, it states, as was under the former law, that if affidavits are received, the fact that it's privileged, there are privileged communications, for example, under the social worker privilege, won't bar their receipt if the person was notified and intelligently waived the privilege. So the statute still contemplates receipt of documentary evidence.
Your time is up. Thank you.
Thank you.
All rise. Hear ye,